Welcome to all of you, both here at CEDR and to those of you joining us online. I'm Laurence Katz. I'm a dispute resolution partner with Gunn & Cook and also a civil and commercial mediator. It's a pleasure also to be joined on today's panel by Laura Gill from Confidentiality from Canada, by my partner Khalid Maid, by Susanna Schuler from CEDR, and by Paul Sills from Arbitra International. And they'll introduce themselves briefly, very shortly. And also, pleasure to be joined by Tina Benson from Confidentiality's London office, who'll be looking after the online Q&A. So for over 2 decades, the English courts merely encouraged mediation, but as we know, with a light touch, cajoling parties to mediate, but not compelling them. So nudges rather than mandates. That all changed with the Churchill decision in November 2003. And with the Court of Appeal's ruling, court-ordered mediation has now taken its place in the English dispute resolution landscape. Of course, England is not the first country to take this step. Countries such as Italy, Canada, and New Zealand have all grappled with the same challenges that we now face. How do we have mandated mediation without mediation losing what makes it meaningful? What turns court-ordered mediation into a driver of resolution? And what risks reducing mediation to a bureaucratic box-ticking exercise, which merely adds delay and cost? So, panel today will be looking at some of these questions, and I'll turn now to co-panelists to introduce themselves briefly.
Thanks very much, Laurence. It's fantastic to be here. Nice to see you all. As Laurence mentioned, I'm a partner at McCarthy Tétrault. It's a Canadian law firm. I work in our Calgary, Alberta office, and I'm a litigator. I do primarily arbitration, but some court work as well.
Thank you. I'm Khalid Muid. First of all, when we were planning this event, I counted there were 26 other events happening simultaneously. So we're really grateful that you chose us. I'm a partner at Gunn & Cook, specializing in litigation and arbitration. Previously, I was at Herbert Smith and Clyde & Co. Last time I was here in this room, I was being trained to be a CEDR accredited mediator. And my trainer, James, is here sitting at the back. So it's good to be back here.
Thank you. Yeah, so I'm Susanna Schuler. I'm from CEDR. I'm one of the directors. And whilst also being a mediator, I'm also a trainer, facilitator, and have the privilege. I see some of the accredited mediators here and actually standing in this training room again next week for a new cohort. And yeah, I'm representing, I think, Europe today, which is like a big responsibility. And looking forward to the discussion and your questions as well. And hello online as well.
Hi, everybody. Paul Sills. I'm an independent arbitrator and mediator based now in London with Arbitra, on 1 floor down in this building. Originally, though, from New Zealand, like the director of CEDR, James South, where I was a commercial and civil barrister for the grey beard says it all, 30 years. But also been sort of very active in the mediation market there since mediation came into the commercial sphere, and as a mediator for the last 20 years. So I am today representing the other side of the world in New Zealand. We'll be having our discussion. So welcome, and thank you all for coming.
Thanks, everybody. So we're going to have time at the end of the session for questions and comments. And for those of you who are joining us online, please do put your questions or comments into the Q&A. So we're going to look at three themes in sort of exploring the issues around compelled mediation. First of these, just to sort of set the scene, the the current position on compelling mediation in various countries and regions that are represented today. Then most of the session, we're going to focus on how one seeks to ensure that compelled mediation isn't performative and is actually a truly effective form of resolution. And finally, we'll spend a short period sort of looking into the future. So to start with the first of those themes, I'm going to ask you, Susanna, perhaps to pick up on the current position on compelling mediation in the European region.
Yeah, so when we say European region, of course, we're not covering
excluding England.
Exactly. Well, it's like focusing mainly on Italy, because they were the first sort of like Western country and nation to embrace mandatory mediation. I quite like the word compelling mediation, because is it compelling to mediate? And I think Italy did quite a bold move in 2010 to do so. And I know there was a lot of like upheaval. Okay, is this okay? It's against the main principle of voluntary access to mediation. And I think they developed quite a lot. Maybe we'll talk about that later. And there were, at the beginning, of course, some problems with where people not really trained and nobody had really confidence in doing so. But if you look at it now, they were actually quite successful to do so. I mean, you see France has started a little bit later, has now compelling mediation for all administrative cases. And since 2020, that is now a law. And Spain is now embarking on the journey as well, and with a little bit more agile approach. And we will look into that later as well. Whilst speaking for Germany, they are still fairly behind in Switzerland as well, but I trust they will follow.
Laura, do you want to pick up on the Canadian perspective?
Yeah, happy to. So in Canada, the concept of compelling mediation really goes back to what the rules of court in each of our 10 provinces and 3 territories require. In all of them, there is now some mechanism to either request mediation or to be forced to enter into mediation at some point. In Alberta, where I practice, the Alberta Court of King's Bench rules actually mandate that you have to do a judicial dispute resolution or a private mediation in order to get a trial date at all. So there's some limited exceptions, but it's really hard to meet them. Saskatchewan, another prairie province, has a very robust system for mediation. All cases have a stream for mandatory mediation after the pleadings close. In other jurisdictions, the court, when it's not mandatory, can order mediation upon an application of a party. Or in some instances as well, it's within the court's inherent jurisdiction or case management function to order mediation. So it varies, but in every single one of the provinces and the 3 territories, there's some form of mediation mechanism in the court rules.
Carla, do you want to describe the position here?
So in England, there are 3 important cases. I'd like to take you back to 2004, where there was a decision in the case of Halsey versus Milton Keynes General NHS Trust. In that, the court ruled that it could not order or compel mediation. However, and it upheld the voluntary nature of mediation. However, it remains to this day an important precedent for what it said on cost consequences. It said that a party that unreasonably refuses to engage in mediation could have a penalty in costs, even if it later wins the case. So that's 2004. We then fast forward to 2023. We have the important Court of Appeal decision in Churchill versus Merthyr Tydfil Borough Council, where it was held that under certain circumstances, courts can stay proceedings and order the parties to engage in mediation. So this is the authority on mandatory mediation, and it overruled the long-standing precedent in housing, opening the door for courts to take a more assertive role in encouraging or mandating mediation. Then we go to 2024 in a High Court decision which applied Churchill. This is the case of DKH Retail Limited and City Football Group Limited. So that's the Manchester City Football Club. The claimant applied for compulsory mediation at the pre-trial review stage. So very late in the proceedings, often with just 6 to 8 weeks to go before the actual trial. The defendant, Manchester City Football Club, they objected on the basis that the parties had already spent a great deal on legal costs. The High Court acknowledged this, but they nevertheless ordered the parties to take part in mediation. And the court was vindicated because the parties successfully resolved their dispute through mediation. And we've seen reforms in the civil procedure rules that came into force in October last year, whereby the court's overriding objective requires it to not just encourage mediation, but it has been strengthened so the courts can now order and encourage mediation. Now I'm going to say something rather controversial, and I would like the audience to see what you think when we have questions at the end. We've got to ask the question whether this is a form of privatisation. Now, privatisation is a very controversial topic in England, but is this a way of the state putting resolution of disputes in private hands? So instead of the state paying for the courts, the infrastructure of the courts, paying the salaries of the judges, are they putting it in the hands of private mediators? Obviously, privatisation in a political context has a different meaning. In England, other than the healthcare, almost everything else is privatised. Utilities, even something that's an actual monopoly such as Royal Mail. This is very different. I mean, the state is not, or the courts are not privatising it and putting it into the hands of a single institute, let's say CEDR or CMC, but it's nevertheless putting resolution of disputes in private hands. I'll stop there.
Thanks, Alan.
Paul. Well, I'm going to start by responding to that controversy and put my arbitrator's hat on and say I thought that privatisation was called arbitration, but I might be wrong. New Zealand's it's really interesting where it sits from a sort of this standpoint, because New Zealand was a very early adopter of mediation into the civil and commercial spheres as it sort of transferred out of, as some of you will recall, out of sort of employment and family court disputes, and we started using it sort of really quite heavily from the mid-90s onwards. So it's about a 30-year-old process. But as an early adopter, New Zealand lags very much behind all of these jurisdictions, very much behind the UK, which it often follows, in this idea of voluntary versus the compulsion of mediation. And so in New Zealand, and I'll conclude by saying I think that's changing, but in New Zealand we've had probably a 20-year debate with senior courts around this question of access to justice, which has always been one of the arguments put forward around this idea of compelling people to not have their day in court effectively. And that, of course, is not what mandatory mediation is doing, because there's always a pathway through to the courts. But that's been the argument. And that argument has kind of been put to bed, I think, for most jurisdictions around the world. So New Zealand at the moment, it's purely voluntary. We don't even follow the Halsey decision in terms of cost consequences. That's sort of how far behind that framework of thinking that it is. But I think I am told that there are changes to the senior court rules that are going to start introducing this idea of more than, as Laurence started with, more than just nudges. So New Zealand at the moment is very much just a nudge. The courts and a good judge will occasionally nudge people into the right position, but compulsion, yes, there is some compulsion, and we'll talk about that over the rest of the questions, but from the court perspective, no, and we are lagging behind watch the space for that change, but that's where we currently sit.
Right, thanks, everybody. So we're going to move on now to look at what makes compelled, as I'm calling it, rather than mandatory or compulsory, compelled mediation truly effective, and what might turn it into a box ticking exercise. Laura, perhaps we can start with you. What do the Canadian courts and court rules do to encourage the effectiveness of compelled mediation?
So, yeah, I think the discussion starts looking backwards. So 10 or 15 years ago, the idea of pushing parties into mediation, it was a debate, because it's, are you affecting parties' abilities to settle their own disputes through the court system? But we've now obviously very much moved past that, and we're in a situation where all the courts have some form of mediation. So the real driving force in Canada for having mediation through the court system has been access to justice, similar to what Paul said. Is, you know, the wait times to get a trial date are long, and, you know, the costs are high. And even for commercial parties, you know, this is less of an issue, but it's still an issue. So there's the length of time to get to a trial, 3 to 8 years to get a final determination in Canadian courts. And then, you know, courts have a limited number of remedies that they can offer. You can get something different in a mediation setting. So there's been a lot of pressure on the courts to resolve their disputes more quickly. How a judge will make a mediation effective, there's no one way. It really depends on the judge and the training they've had, the experience they've had. Some judges occasionally will use a binding mediation process, but typically judges will have the parties set out in a brief beforehand, you know, what attempts have been made previously to settle, what offers have been made as between the parties. And so you kind of force the issue, the key issues to the judge and for the parties right before the mediation. But the bottom line is there's no one approach to make the mediation setting effective. I think where the court systems have gone is they've realized that based on the data that's available, is if you have a judge-led mediation, the chances of success and settlement are quite great. The data is something like 80-90% of judge-led mediations will settle, maybe not at the mediation, but sometime after and before trial. So it's really become a process of getting the parties into the room. And the research proves that that will often make the settlement process effective in some way, whether in that setting or after.
Thank you. And Khaled, what about here? What have the courts and court rules here done to encourage the effectiveness of compelled mediation?
Yeah, so in terms of making compelled mediation effective, so there are 3 points that I'll make. First of all, there is a shift in the judicial attitude. Secondly, cost consequences. And thirdly, we have court integrated mediation schemes. So on to the first point, the Churchill decision compelling mediation has confirmed that that is compatible with Article 6 of the European Court of Human Rights, the right to a fair trial. And judges routinely ask, whether the parties have attempted form of ADR mediation, and courts are now increasingly willing to pause proceedings, stay timetables, and make orders for parties to engage in ADR. So this is creating an environment in which settlement or mediation is normalized, and it becomes part of the case narrative rather than just a separate track. That's the first point. And secondly, we've already touched on the cost consequences for refusing to engage in mediation. Thirdly, there is the court integrated mediation scheme. For small claims that are less than £10,000 in value, there is already a scheme in place. Now, I'm not a betting man, but I think this could increase to £25,000, which is the value 10 to 25 for fast track claims. The Central London County Court, they've got a mediation scheme for multi-track claims. with values exceeding £25,000. In certain courts, such as the Court of Protection, family courts, mediation is not only encouraged, but often expected to feature as part of the case progression. So we're not just seeing mediation being built into the infrastructure of the dispute resolution landscape, not just as an alternative, but as a procedural step in its own right. So in short, the English courts are moving decisively from merely encouraging mediation to actively engineering it into the litigation process. With the case law developments, the reforms in the civil procedure rules, and financial pressure through costs, the message here is very clear. If you ignore or dismiss mediation without good reason, you do so at your own peril.
Thanks, Alan. And Paul, how has this question of making compelled mediation truly effective been approached in New Zealand?
Well, based on my earlier comments, I can't talk about what the courts are doing because, of course, the courts aren't at this moment doing anything in particular with it. But I'll use firstly, the New Zealand government over the last few years have been quite happy to wade into the space of compelled mediation, and quite effectively. And there's one really good example which I will talk about, which is some of you might be familiar with in other jurisdictions, farm debt mediation scheme. So it's I think legislation that's in all parts of Canada and in Australia, with this idea that there's compulsory mediation before a secured creditor can take action against farm assets. The rationale being that typically if farm assets are secured against, of course, not just the product of the farm, but the land, the building, etc. So the idea being that if a farmer loses to a secured creditor, they are losing lock, stock and barrel. So that's a compulsory scheme. It's been in place since 2019. There's been numerous compulsory mediations under it. But rather than leave it to the parties to work out whether that's going to be an effective scheme or not, there's some very key criteria to make it effective, which hopefully will spark up some conversation at the questions end, because the legislation requires that the parties must attend with the authority to settle. To mediate farm debt mediation, you have to be particularly trained in it. So there are 2 accreditation bodies in New Zealand where it's not enough to just be a mediator. You must be accredited as a farm debt mediator, typically with a history in the farming sector. Either that's your legal practice, or like me, you grew up running around chasing sheep. Two really key points, I think, which hopefully we can debate is, firstly, the mediator must report back to a third party. And for some of you, alarm bells might start ringing at that suggestion. So the mediator does a report to the Ministry of Primary Industry, which is the entity that governs the scheme, and you report on the mediation on a prescribed form in reasonable detail. And then the catcher is there is an undefined requirement to conduct yourself with good faith. And so the report, the primary purpose of the report is to work out whether, and typically we're talking about the secured creditor, but not always, has conducted themselves in good faith. And being undefined, you question, what does that mean? Question, around issues, fundamental to mediation, like confidentiality, etc. And so those are the 2, particularly the report to the third party and the requirement to conduct yourself at the mediation in good faith, which are the principal processes that the legislature has put in place to ensure that is going to be at least as effective as possible as a compelled mediation.
Thanks, Paul. And this issue of confidentiality and parties' conduct within compelled mediations, something that's really going to be one that's hotly debated, but there are very strong views on. Susanna. Do you want to look at Italy for us?
Yeah, so of course, Italy had some time now to test various approaches, and they have a mediation law from 2010, and that says that it's mandatory to attend an information session on mediation. So the actual mediation is not mandatory, but to attend the session, so that then parties can actually identify, okay, what is mediation, what it is all about, and what are the risks as well, because I think it's for civil and commercial cases, and especially for commercial cases, you need to identify as well your risks. And if you refuse to attend the information session, then the judge can say, okay, you have to pay the entire court cost. So you have the cost risk, which I think is possibly the most, which I heard in all countries, the biggest lever to make it attractive. But if you then refuse to go to mediation, that has not a consequence. So I think it's called like a soft approach. So I think the voluntary participation is still there or guaranteed, but at least you need to make a decision. So they want the parties to become more accountable and more in charge of the decision to go to court or not. And in the end, what is debated, and again, it would be interesting later to discuss what that means, is the principle also what I would say European law that is similar in France, Spain, Germany, is that the parties have the control over what they want to do and are included. So they are quite successful. So over the last 14 years, that led to a high settlement rate, and it also meant that, of course, the information session, the quality of that is something that is crucial for parties going to mediation or not. And I think the quality of the training, and I had the pleasure to meet mediators in Italy and trained with them as well, is quite extraordinary, the approach, which is actually quite a lot of autonomy, how to encourage parties. So it demands from, let's say, all parties involved a high level of wanting to really engage in the process and not just delegate it to a judge or to the lawyers figuring it out. And confidentiality is one of the key promoters in those information sessions, where they say, okay, you have basically a safe and meaningful dialogue. And it's very clear that the process is also without prejudice. So neither the mediator nor anyone involved can be part of a process later.
Thanks, Suzanne. Perhaps we can come back to Canada now, and Laura just asked, how do the Canadian courts deal with somebody's failure to engage meaningfully in the mediation process when that process is not voluntary but compelled?
Well, generally in Canada, the courts can't really do much. We haven't progressed to the UK where there may be cost consequences. There are in certain jurisdictions what Paul was referring to, a good faith certificate, but the bar is so low to just show that there's been productive conversations that it'll get signed. And really the only times, very small number of cases that it hasn't been signed have been instances where, for example, a lawyer has told their client to not even attend the mediation. So, I mean, these are extreme cases. Most of the time it is just a signed good faith certificate. In family law cases, there's a bit more ability of courts to do something about it. If a party shows up and doesn't negotiate in good faith or participate fully, then the judge could prevent the hearing from going further. I think really in the absence of these tools that are available maybe in other jurisdictions, what judges do is they, within the process, try to bring to the attention of the party who's maybe not participating fully, bring to their attention the risks of proceeding more fully at trial. And you know, it's surprising because you would think that a lot of the evaluation will have already happened between a lawyer and its client about, you know, what are the reputational risks of going ahead with the trial? What are the impacts to your business of distracting your employees with this litigation over several months? But those conversations haven't happened. So I think judges use the mediation process as an opportunity to sort of maybe as a third party from an independent point of view, give some realistic advice to clients on what the cost will be going forward in the litigation process. But we do have this, these are without prejudice discussions, they're confidential. And one tool that as litigators we use, if you go to mediation and you present an offer and you think it's a great offer and it should be accepted and you could have avoided going ahead with the trial, is actually after the mediation, we'll deliver what's called a Calderbank offer in Canada, where it's a without prejudice offer except as a court. So you can, at the end of the day, if you go to court and you beat the offer, you can show it to the judge and get some cost consequences at the end of the day. That's about it.
Right. Thank you. Khaled, what about you? Perhaps you want to just talk a bit about consequences a party may face for breaching an order to mediate. And so also look at how far can the courts actually go?
Absolutely. I think, well, this is the tension at the heart of compelled mediation. That is, on the one hand, courts are increasingly willing to make orders for parties to engage in mediation. On the other hand, mediation is protected by its two core principles: without prejudice, privilege, and confidentiality. So this is, I call it the protected space in which mediation has to operate. So for a party that is not engaging with it in good faith, not engaging with it sincerely, or being unreasonable, obviously there are consequences. I've already touched on the adverse cost orders, and there are other options available to judges. For example, there could be an unless order where the judge would say, unless party X attends mediation by X date, their claim or their defense could be struck out. There could be a debarring order. And I've had that in one of my cases. Pre-Churchill, it was a High Court case, a trust dispute between, I was representing the claimant, and there'd been an order from the High Court that the parties engage in ADR. That was the first order, not mediation, just ADR. The defendants, they refused to engage in ADR. We went back to court. This time, the court laid out specific directions for mediation. And with it, there was the threat of a debarring order, that if the defendants now do not engage in mediation, they could be debarred from proceedings. So those are some of the sanctions that are available to the court. Now the question is, if we have without prejudice discussions and mediation is confidential, how are the courts going to apply the sanctions? Now, this protection, the protected space, it's not absolute in the sense that courts can examine things like if a party has attended and whether they engaged sufficiently in the process. For example, did they send somebody that has authority to make a decision? That's an indicator. They don't need to delve into the substance of what discussions had taken place, but they can look into how the parties had behaved. So the practical reality is that it's enforcement without overreach. The courts will not pierce the veil of without prejudice communications unless in truly exceptional cases. So in short, the courts, they'll walk a careful line. They enforce procedural expectations without turning mediation into another forum for adversarial point scoring.
Scarlett. And what about the approach in New Zealand where someone doesn't engage meaningfully in a mediation process.
Well, the only sort of compelled example I've been working on is, and I'll stick with it, this farm debt mediation. And there, if the ministry decides, based upon the mediator's report, that the party, the secured creditor, hasn't conducted themselves in good faith, then they are prevented from enforcing their debt. So the consequences are significant. So that, you know, these are consequences outside of the court structure. They simply can't go to the next step of enforcing their debt. And so you quickly see, I think, that it would be, you know, a reasonably foolish secured creditor that isn't going to go and at least attempt the mediation in good faith. But I think the bigger question coming out of that, and particularly what my co-panelists have just been talking about, is this idea of, well, how do we prevent mandated or compelled mediation from being performative if we're going to stop short of looking at conduct within the mediation? And by that I mean the subjective conduct of the parties, and so the stuff that is wrapped in without prejudice and within confidentiality. Are we condemning ourselves to a very, as Laura was saying about Canada, reasonably objective and low bar in terms of this idea of, say, good faith? If good faith became the test for whether you have behaved yourself properly at mediation or not, but that test is based upon, did I bring somebody the authority to settle? Did we engage in the process by, you know, did we prepare properly? Did we turn up? Did we exchange documents? Did we provide documents when we were asked to? And these are all the sort of the thinking around this good faith, where there are jurisdictions that have it. But if that is if that's all we are doing to avoid getting into the weeds of without prejudice and confidentiality, how far is a compelled mediation actually going to take us in terms of bettering the chance of that being a fair and reasonable engagement, if I can put it that way? Because 30 years at the bar, I can tell you pretty quickly that I could work around a test at that level in about 5 minutes. And I can guarantee you that every one of my mediations, if I was still counsel, would pass that test, and I would protect my client from cost, sanctions and consequences in court. So I think that's the question, I think, for us this afternoon. I've gone off topic and outside of New Zealand, but I really want to sort of, you know, I think we're all very keen here to hear your thoughts and feedback on that, because I think that's the rub and that's the issue.
And I think here we'll have a similar debate. I'm sure it will be raised at some point in a case about whether a party has discharged their obligation to, under the court rules, to engage in mediation. Susanna, come to you and just ask what courts more generally and mediators themselves can do to ensure that the mediation process is effective when it is compelled.
So I think that's why I think the Italian example is quite good, because they, through their approach, really want to encourage a more genuine approach rather than a procedural to tell this is what you need to do. So if I give, often we know that in mediations, parties are very entrenched in a conflict, and it's sometimes very difficult to step back and actually see what is it that we want to achieve. And are we really in the position to make a good decision? And then you have lawyers, and in most of the cases, smart, good lawyers, they advise you. But they might not be aware that, that they might aggravate the situation. So I think it's important to give the parties and the lawyers the opportunity to actually assess their case, their conflict, and to make the best possible decision when it comes to commercial, personal, and their legal interests. So I think it's important that, and we come back to training later, I think it's also some of your topics, the better trained or knowledgeable the courts, the judges, the mediators, everyone are, the better decisions will be made. And that the ultimate goal is to give access to justice. It's not just to almost have another judge to decide are they now in good faith or not. And I think good faith is one of those. I had that discussion last week in a mediation. It's very difficult. Am I to judge if they're in good faith or not? As a mediator, I would always say I would trust the parties would always come in good faith. If not, it's the very reason why I'm doing the job as well. So I want to trust them. But I also, I think it's the job as a mediator and ultimately also of a court to give parties the autonomy and again the responsibility to know what they're doing. And if it's a very complex case, I think the legal advisors need to be part of that process to really make a good decision. So I think it's all about giving space. And that's the first word in Italy, and I worked with the judge many years ago, and it's called spazi d'intesa. For those who speak Italian, it's like a space where you can step back and assess, and you have someone who helps you, a thought partner, to think it through. And I think that's also the role of the mediator, and should be the role of a judge as well. And I think we're all often far too busy also in courts to get through piles of cases and bundles and etc. that we have that not anymore in sight. And I think that is possibly what I think compelled mediation tries to achieve and should achieve, rather than creating more procedures, more hurdles to assess if parties do that or not.
Susanna. We'll come on to questions in a moment, but before we do, we're going to do some sort of forward-looking thinking, and I'm going to ask each of the panelists if they could select just one key focus or change aimed at making compelled mediation more effective. What would that be? Or would you like to take over?
I'll pick the quality or the training of the mediators, which I think is a very big issue within this space, and potentially the need for some additional core training needs when you are dealing with a mediation that is compelled. For example, how you manage reluctant participants who don't want to be there. How you deal with power imbalances. Power imbalances in mediation are always there. They are likely to be increased when you are in a compelled situation. Process transparency. If I'm wanting these people who have been forced into this room to actually buy into this mediation process, then my ability to be as transparent as possible about that process is probably a key additional training feature. And how the mediator deals with this idea of coercion, and that will often, I think, come up from one party or the other, and how we deal with that from both an ethical and a process design perspective is important. So mediator training.
Right. Thank you. Laura.
I have the same answer as Paul, and I think Susanna touched on it too. I mean, education of the mediator is so central to ensuring that there's an effective outcome. In Canada, assuming you're doing a private mediation, there's a real mixed bag of continuing legal education training. There's not really uniform regulation. There have been some advances with the law societies, but really we're not there yet. For the judges, in order to be on the list of judges who do these judicial dispute resolution sessions, there is some training, but it's not very involved, and there's no kind of mandatory level of participation within the training. So I think, helpfully there's been a recent change to the judges' ethical code of conduct in Canada, which has implemented certain standards where, in order to conduct these JDRs, the judges have to have a certain skill set and say that they do. But really, the existing training has to be modified from what it is now for the judges, from an interest-based approach to more of a evaluative approach. So actually giving an opinion within the mediation to push the parties into a resolution. I guess just brainstorming, and I think Susanna kind of touched on this. One thing that would be helpful in our jurisdiction is to have some kind of training that included both the judges and the lawyer. because the training is undertaken in silos. The judges do their trainings through the National Judicial Institute, and the lawyers, to the extent that they want to become mediators, it's through courses here and there. But I think in order to really move the process to be more effective, it would be good to have some type of training where both the judges and the lawyers participated tandem.
Right, thank you. And Susanna, what would you choose?
Yeah, so I think it's in that same vein. So it's something that involves various parties. So I think for a mature jurisdiction, I think it's important that the judges, the lawyers, and the courts are not only educated, but actually have an idea, because mediation is not a panacea. It's not just, okay, you have to go to mediation. It's also to really assess again what is important. And I think being evaluative in the recommendation, but possibly not in the process. Or I think the parties should choose what they want. But it's also to have, because for a judge, I think they have a reputation to lose if they make almost the wrong decision. And I think that's something I see here in the UK. It's quite important to involve the judiciary very early on, because they might be afraid to refer if they're not quite certain, is that the right thing to do, and how will I look like, and will that be a precedent or something? So I think it's important to really do this carefully. And I think it was mentioned beforehand, to involve everyone. How should that be? And go to the universities, involve the law students. And I think what we often do is like do so-called mock mediations, actually make people experience it, and then see also what is culturally appropriate and with regards to the jurisdiction. I think we make already the difference between common law and the law in case law also in Europe, where you have, I always say that's a deductive and inductive approach. So you go from an abstract rule which you apply to a case, whilst here in the UK and the US and Canada, you have like almost a case and then you have to find a rule. So there are different ways to approach that. So it's better training, it's ongoing conversations, and not prevent like one of these over lawyerization. So I think it's important that everyone is involved. And at the end, the parties need to have a voice. So I think it's to involve them.
Thank you. Harlan, what are your thoughts?
So if I had to choose one key change to make compelled mediation truly effective, it would be a dedicated mediation act. So hear me on this. A statutory framework that gives mediation the same structural legitimacy and clarity that we've had on arbitration since the Arbitration Act of 1996. Why a mediation act? At present in England and Wales, it's compelled mediation is largely governed through a patchwork of case law, procedural rules, and best practice. It works, but it's not always very clear, especially as we now shift from voluntary to compelled mediation. By contrast, arbitration has had the benefit of clear statutory underpinning for nearly 30 years, giving it certainty, legitimacy, and predictability. So what would a mediation act cover? What we would like to, would expect to see? First of all, it would codify core principles around without prejudice privilege, confidentiality, voluntariness and party autonomy, and mediator neutrality and duties. So that's the first thing. Secondly, it would clarify the scope of the court's powers, when and how a court can compel parties to mediate, what constitutes compliance with a mediation order, when courts can draw adverse inference for failure to mediate. Thirdly, a mediation act would protect the integrity of the process. It would safeguard mediators from being called as witnesses. It would limit disclosure of mediation communications. and it will also define exceptions for misconduct or abuse. And finally, it will set the standards for mediators and institutions, some of which we've heard from my learned panelists. So we wouldn't be the first to have a Mediation Act. There is already precedent. Many jurisdictions, including Singapore, Ireland, Italy, and India, we have lawyers here from India today, they've enacted mediation acts to bring clarity and strength to their frameworks. The EU Mediation Directive also reflects that trend. The Singapore Convention on Mediation shows a global appetite for giving mediation a more formal legal status. So my final thought is, if compelled mediation is here to stay, and it is, then we owe it to the parties, to the lawyers, and to the courts to make it more than just a procedural experiment. A mediation act could be the structural change that turns compelled mediation from a well-meaning idea into a truly embedded, respected, and effective form of dispute resolution. Thank you.
Thanks, Carl. So we've got some time for questions. If there are any questions or observations, please.
Khalid, I'll take you up on the Act and your privatisation. I'm someone who remembers privatisation in Maggie Thatcher's days, and we had as a WAG used to say, you privatise profits and you socialise losses. So I think this is the situation we find ourselves in general in legal practice around the world. And when it comes, you say, I need an act to give me the framework to ensure, I'm not sure what. And I'm saying that the uncertainty exists, not my interpretation, because of the status of the law. It's because of the different requirements and segments of businesses that have to access alternative dispute resolution. On the high end, it's all private. And as a businessman, I'm governed by various fundamental fiduciary duties. To maximize shareholder value, I have to consider alternative dispute resolution. So I don't think the legal professional judges can really interfere. I think the complexity of the way, I mean, look at the what are the courts really good at? Assessing evidence. Yeah, let the post office, they're lousy at it. So on complex things, forget about it. Then you have a whole series of smaller, more general, it's a different segment and it applies very well. And I'd ask Laura about, is, in some respect, you're trying to put a Band-Aid around the whole thing, and I don't think it's going to work. On the Italian thing, I'll take you up on that because I'm an Italian lawyer. I'm sorry. I think you've really misunderstood. The reason it exists in Italy is to get rid of the backlog, because we had cases that went on to 20 years. And to say that the Italian system is a paradigm of what, I mean, the real issue is that it's it doesn't affect Article 6. I think that's really all this debate has ever been about. Article 6 is a standalone article, and it's your access to justice, and does this destroy your access to justice? We do it through awarding cost consequences. The Italians have very minimum cost consequences. It's really that you get rid of the backlog. And I think in this country, it's going to become increasingly bad. So I'll leave it at that.
Okay, well, thanks, Philip, for that.
Sorry, Harry, we come back to you. Because your reference on the Mediation Act is quite interesting. But my question is, in terms of CMC regulation, etc., and in terms of the breadth and different styles of mediation and areas of mediation. Are you thinking solely of civil and commercial, or does this extend to community, workplace, and other forms? How would that fit within a mediation act? How would you cover these different areas of mediation? Would some areas be excluded, or?
Well, I think obviously if you are having legislation, it would have to be comprehensive, probably have to cover all of those things. But I was touching simply on in the context of compelled mediation and the challenges that we have. And I took you through areas that a piece of legislation could potentially clarify and codify it. Even though in England, it's a precedent-based system. Things develop through case law. But we could be waiting a very long time, for things to develop through cases. That's the default way for these things to develop. But a legislation could perhaps fix all of those, answer all of those questions.
But in terms of you liaising with, for example, the CMC, which at the moment has the position of covering various areas of mediation, and then we've got family mediation scheme. How would that? Because we know there's a bit of conflict within the mediation.
Oh, there's a mic.
Oh, sorry. Yeah. Can everyone hear me now? Sorry, because we know that there are sort of tensions between lawyers and non-lawyers in mediation in the UK. I mean, in some other jurisdictions, it's pretty clear cut, like in the United States. Certain areas appealed are definitely for lawyers. But here, it's more fluid. So how do you keep a wide and diverse mediation community happy with the Mediation Act?
Good question. I don't know the answer.
You had your hand up before.
Yes,
If you wouldn't mind passing the mic over. Thanks.
I'm really sorry, but I'm coming back to Khalid again and going back to the first observation about mediation really only being about backlogs and dealing with the procedural difficulties. I'm a King's Counsel. I've been a commercial lawyer for more than 30 years. I've been mediating in one form or another for more than 30 years. And I don't see it as privatisation. I see it as the chance for parties to take back control that they have reposed in either a court or an arbitrator or arbitrators, and then they lose control and they watch their costs spiral. And it gives them a chance to sit in a room and think, do I really want to be doing this with my money, or do I want to carry on with the day job, which I'm much better at? So I'm not so sure about a mediation act, but I don't see this as privatisation. I see it as a part of an absolutely essential part of a commercial lawyer's dispute resolution toolkit. And great things happen at mediation. And I think that with a skilled mediator, the difficulties about compulsion can at least be parked. You can say, look, park it, try it for the day. Because you often get people who you are not sure about whether they're in good faith or not. Personally, if I thought for certain someone was not in good faith, I'd stop. So these are very pragmatic things. They're not the sort of high level observations that you are making, but at the cold face, that's how I think it works.
We've got a couple of questions here to start. We've got a lot of questions. We're going to go on to about 5:10, and then we're going to continue the questions over drinks. I don't know if there are any online. So we're going to start here. This gentleman.
Thank you very much. I'd be interested from the panel's point of view about privatisation thing, going back to your point. But is it about the issue of order? And when you look at things like the employment tribunal, we normally have to go to conciliation first. Should we be thinking about use of ADR as mediation or whatever prior to the actual issue? And then that might take a lot of the tensions that we'll be talking about. I'd be interested to the panel's view on that.
You want to pick up on that?
Yeah, I'll start with that. That timing is one of the fundamental questions in the success or non-success of mediation. And one of the biggest issues we have when we are compelling mediation, whether it be by way of an escalation clause, dispute resolution clause in a contract, or by way of court imposition, is getting that timing right. And the reality is, often your point would be the perfect solution. And equally, the reality is, there are many times when the parties simply are not ready at that point in time. And so one of the biggest things for me, I think, in the success of designing a process around compelled mediation is the flexibility within that system to get the timing right. And inevitably, that's going to fall on the shoulders of counsel and fall on the shoulders of judges to try and work out. Because if you can get that, if you can get the question of timing answered, then I think, quite frankly, whether it's a voluntary mediation or a compelled mediation becomes somewhat an academic thing, because you do get into the room, you do start those conversations, and a compelled mediation around a dispute resolution clause in a contract will often yield a great result, but it's still mandatory mediation. We kind of seem to forget that. So timing is essential. And I think, back to the point over here, I wanted to comment on that as well, is we've got to remember who we're providing the service for. And unfortunately, and I'm guilty as a barrister, we spend way too much of our time theorizing these things around what works for the legal system and what works for us as lawyers, and not what works for us as commercial parties, and what we should be doing in the interest of clients. Because if we looked at it the way I think we should be looking at it, we'd be having some quite different conversations about the reality of this stuff. So let's not be guilty of all the lawyers around the world who hijack mediation and say, well, actually, it's part of our legal solution now. It's not. We just pretend that it is. It needs to be a part of the solution for the parties whose interests we are serving.
Thanks. Jonathan.
Thank you. Coming back to your last question, one point for the future. A word that hasn't yet come up is creativity. And it strikes me that's incredibly important in this context, because mediation, with or without a Mediation Act, is as good as the mediator. The majority of mediators, at least in this country, are lawyers. Lawyers tend to focus on the law, whereas the good mediator needs to go a lot wider than that. And what comes to my mind is a brilliant concept that William Urey came up with. There's no short title, unfortunately, but it's balcony, bridge, third party, or constituency. And he put together a little international working group, which I was happy to join, where we explored this. The basic element that makes this buzz is creativity. So I would like to, yes, the need for education was recognized, but I would like to see a conscious focus on creativity and what that means, which is much wider than just the law, as part of the future. Thank you.
Thanks, Jonathan. We've got a lot of questions. I'm going to take one more on this side of the room over here.
Thank you.
If I can just pass the mic. I'll take one final one on the other side if we have time.
Just a question to anyone who wants to answer. I won't target Khalid. I just want to understand. I come from India, so I'm from where the Act also. So I just want to understand, where does mediation and access to justice, if you're talking about, is it access to justice? Because if parties are taking control of their own dispute or problem and sorting it out, facilitated through a mediator, would you still call it access to justice, or is justice something different from what mediation is achieved? That's something I just wanted to, anyone could throw a light on.
No, I think the short answer is it is a still. access to justice, of course, whether it's facilitated through compelled mediation, or parties may voluntarily, seek to resolve their dispute through mediation. Now, I do want to come back to the point on privatization. I'm glad I mentioned it because it's generated a lot of discussions. And just going back to, I think, your Fiona Macready, Casey, from Keating Chambers. So what I said was that we have to ask the question, and you've answered the question from your perspective, that it's not privatization. I think the concern is, of course, where it's voluntary, we don't have any questions that we can ask, but where parties have already started litigation. And in the example that I gave from the High Court from last year, and involving the Manchester City Football Club, where they'd even proceeded as far as to the pre-trial review. Obviously, it worked out in that case, but the question is, then at that stage, or at any stage, to then put it into private hands. But this is one for the drinks and canapes, not
that. Sorry, can I just address the question on access to justice, because it sort of feeds off what I was just saying about from whose perspective are we looking at this process, because that comes back to the same point. From whose perspective are you looking at access to justice? Because if I'm a party, I don't care about legal precedent. I don't care about your case law. I don't care about 800 years of precedent following the Magna Carta. I care about my dispute being resolved. And so if you ask me as a party what access to justice is, it's getting my case sorted out. And if mediation provides the forum for that, I have had access to justice. I don't need legal precedent to go home and say, I've sorted out that dispute. I can get on with my life, my business, my divorce, my whatever.
Sorry, just want to clarify
Can
one thing.
I just come? We're going to have literally up to our last minute. So what I'm going to do, I'm going to give one question on this side of the room to Roger, can get the mic, and
not 100% sure that the mic's working, but anyway,
It's a good talk.
I'd like to talk about the elephant in this very, very big room, which is what's happening since Churchill and the change in the civil procedure rules. And I'm finding in the cases that I'm mediating that more and more people now are actually treating it like a tick box exercise, which is very frustrating. They don't say they're doing that, but you can quickly see whether they're engaging properly by the kind of offers that they make or don't make. And I suppose we've got the danger of being careful for what we wish for, because the increasing number of mediations, certainly in my experience, is showing that if people feel that they have to mediate because they're required to mediate, then some people inevitably are going to be going through the motions.
Right. Well, thanks very much. So thanks everybody for your questions and your observations, and thank you to all the members of the panel for today's session.